another episode of Law Schoolers. Today we're going to be talking about priority within secure transactions. And what do I mean by that? Well, priority is essentially who gets first dibs between creditors if a debtor ends up defaulting on their loan or transaction that ended up happening between this agreement with the debtor and the creditor. So priority in section 9201A, it says, except otherwise provided in the Uniform Commercial Code, a security agreement is effective according to its terms between the parties against purchases of the collateral and against creditors. So really, what is that saying? Well, all that section is saying is a security interest is going to prevail over purchasers and creditors unless there is an exception. And I'm going to restate that one other way. All I'm saying there is if you have a secured transaction, you're going to have priority over those who do not have secured transactions. You can have a creditor that is not secured, and the secured party is going to have first dibs over that party. That's essentially what I'm saying. And, of course, there are always exceptions to this general rule. But that's really how priority works. First priority, secured party. Second party, unsecured party. And that's essentially how priority focuses on. But in this episode, we are going to be focusing on lien creditors and how lien creditors compare next to other potential parties. And what do I mean by a lien creditor? I just mean a creditor that is not a secured party. So, who wins between a secured party and a lien creditor? Who gets first dibs between a secured party and a lien creditor? Well, this is outlined in section 9317A2. A lien creditor is going to have priority over a secured party if the creditor interest arises before the secured party either perfects or authenticates a security agreement and files a sufficient financing statement. So what that is just saying is lien creditor is going to win unless the secured party either perfects or has a security agreement and files a sufficient financing statement. So those two things there are going to allow the secured party to beat the lien creditor. What about a lien creditor versus a secured party who has a PIMSI, purchase money security interest? Well, this is outlined in section 9317E. And this is an exception to the exception. Basically what that says here is that a secured party is going to win unless the security interest is a PIMSI. So the lien creditor is going to win unless the security interest is a PIMSI. Section 9201A says unless the secured party fails to perfect or file before the lien creditor takes an interest. That's going to be your exception there. I do want to note too that this is different than perfection of a PIMSI. This is because perfection of a PIMSI automatically is perfected if it's a PIMSI in a consumer good. Now, if you're just looking, you take off the consumer good part of it, and you just have a PIMSI versus a lien creditor, well, then that is going to end up being the rule, is that the secured party is going to win unless the secured party fails to file or perfect before the lien creditor takes interest. All right. What about future advances? How does that work in this scenario? Well, future advances, what a future advance is when you have a security agreement or an authentication agreement between a creditor and and the debtor. Ultimately, what happens a lot of the time is there is a clause that allows the creditor to provide additional money to the debtor. and these are called future advances. I want you to picture the following timeline. First, picture that the creditor and the debtor get into a secure transaction. This initial loan is secured. This is then perfected by filing a financing statement. And then picture that a third party is going to obtain a levy on the collateral. And then finally, after that third party obtains a levy on the collateral, the future advance, meaning that additional loan, is issued by that initial loan provider. Who is going to win, the third party who obtained the collateral or the secured party on the initial loan based off of this future advance? Who's going to win? If the debate is about who gets this additional money, is it going to be that third party levy or is it going to be the initial loan provider? Well, if the advance is made within 45 days after the levy, or if the advance is made later than 45 days and the secured party doesn't know about levy, then the secured party will have priority in that collateral. Okay, one last thing I want to talk about here. What happens if you have a security interest versus a statutory or possessory creditor? What do I mean by statutory? A good example of that is a mechanic's lien. What do I mean by possessory? This is somebody who has possession of the collateral. So who wins if that creditor versus a security interest? Well, a possessory lien over collateral is going to have priority over the security interest if, first, the lien holder has possession of the collateral and the statute that created the lien does not have an exception. So that's going to be outlined in Article 9, Section 9333. Essentially, what happens there is possession is going to win if they have possession before the other party has an interest in that collateral. And there's no exception. But that's essentially the first step that I want to talk about as far as lien creditors go. Who wins between a secured party and a lien creditor? Who wins between a PIMC and a lien creditor? Who wins between a secured party and a lien creditor if it's a future advance? And who wins if it's a secured party versus a statutory possessory creditor? But that's everything I wanted to talk about today. It's a bit of a confusing topic, and priority can get a little mixed up sometimes. But that's all. Have a good one. Bye. Thank you for listening to this episode of the Law Schoolers Podcast. If you enjoyed the show or the material shared on the Law Schoolers website, you can support Law Schoolers by becoming a patron at patreon.com/lawschoolers. I also wanted to provide a quick disclaimer. Nearly all Law Schoolers material is unedited due to the sake of time and a desire to keep the content as raw as possible. Additionally, the material is only provided for educational purposes and is not to be used as legal advice. If the material is used as legal advice, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show.